Okay, I guess we're meant to get started now. Welcome, thank you for coming. Welcome to AI and Free Law. I'm Craig Newton. I'm co-director of the Legal Information Institute at Cornell Law School, joined today by Sara Frug, who's the other co-director at LII, and Tim Stanley, who is, of course, the CEO of Justia and the furnisher of all the prizes at the raffle later on today. So we're going to split this up into thirds, roughly. Sarah's going to go first, then me, and then we'll leave the rest of the time for Tim as the main attraction. We found if we put Tim first, everybody gets up and leaves after he's done, and it's disruptive and it hurts our feelings. So we always put him at the end when we do this. So without further ado, I'll turn the mic and the clicker over to Sara.
Thank you. Good morning. As Craig said, I'll be talking today about using all kinds of AI to increase public understanding of the law, what we've been working on, and what we've been learning from it. I touched on this at Kelly a year ago, which I mentioned because at that point, ChatGPT had been out for around half a year and had already started to train the general public to experience the first few climbs and drops on the generative AI roller coaster. But of course, this isn't LII's first roller coaster. So first, a bit of background. We like to remind ourselves and you all, and sometimes the world, that we stand on the shoulder of giants. Our co-founders provided framings for our work that are just as relevant in 2024 as they were in 1992 when they first launched the LII. Whether it was Peter Martin reminding us that the law belongs to the people, or Tom Bruce pointing out that if ignorance of the law is no excuse, the government has its work cut out for it, informing a public expected to abide by myriad regulations affecting the work we all do every day. We keep in mind an audience of the general public, law learners from middle school to law school to training school to no school. Although keeping such a broad audience in mind has paradoxically made LII more accessible to members of the legal profession who sometimes tell us things like, I have Westlaw, but I hate logging in. We've oriented toward making law understandable to folks who are using it for work or for school. Whereas in the early days, the work involved making manifest the implicit structure within legal documents and mapping them to take part in the emerging World Wide Web. Subsequently, the work shifted to connecting siloed information resources to one another, using emerging technologies to connect regulated objects to external ontologies and the research that were used to organize them, and to make use of the language of the law to discover rules. Now, over the past few years, off-the-shelf technologies and knowledge organization schemes have begun to evolve so quickly that we've taken an almost entirely new approach to how we envision experimentation. Now, yesterday, some of you heard LII's original content collections manager, Nicole McCarthy, speak on what LII learned from hosting our first hackathon. Organizing the WEX Legal Dictionary and Encyclopedia, including the hackathon and Nicole's mentoring of the Taxonomy Capstone Project from UW iSchool student Amanda Chin, dovetails with applied research work supervised by LII's language and data scientist, Dr. Sylvia Quache, and graduate and postgraduate mentors for Masters of Engineering student projects. Across millions of documents, contextualize and browse use cases become even more complex, even more quickly. And since last year's Kelly conference, we've focused on removing roadblocks to progress and paid particular attention to evaluating newer ontologies, particularly the Standards Advancement for the Legal Industry Alliance's Legal Matters Specification Standard. If that's too much of a mouthful, we're calling it the SALI ontology for short, as I think it's better known as. And we've been using this as a way of making a basic set of legal topics, SALI's areas of law, available across everything we carry. Now, using such a generalized set of topics, the SALI ontology has about 30 top-level topics and a total of just under 150. Despite the legal practice management orientation of the ontology, provides a view of the subject matter that is designed for a set of practical use cases and not the worst starting point. Now, coming off the first few thrills in which ChatGPT introduced the public at large to the phenomenon of language model hallucination, we decided to focus on seeing where we might find alignments between top-down information organization systems, as with the hierarchical combination of labels and descriptions made available by the SALI ontology, and bottom-up unsupervised topic models, essentially statistical representation of the contents of the corpora we work with. We hope that these explorations would make it easier to provide support for editorial production of comparative resources and help the public understand the context of documents they've landed on from a Google search, which is, after all, how most people get to us. Now, by the time we had our next new batch of engineers after the summer of last year's Cali conference, in this case, a Cornell MEng student, Adrian Hilton, who subsequently became a mentor to the next batch of MEng students who worked with us, as well as a recent JD graduate from Cornell Law School who had done an undergraduate training in engineering. The consensus at that point was that retrieval augmented generation, if you were in Jonathan's session in the last session, you are very familiar with this already, but to summarize briefly, in which a large language model would be fed a curated set of documents to use as context for a prompt, was looking like the most viable approach to addressing hallucinations. And so we set about seeing just how quickly we could throw just how much spaghetti at the wall. Although we were able to create some better glide paths, this was the first time students were able to use tools like Google Colab almost exclusively, putting a stop to reports from the students that they submitted weekly that sometimes included lines like, my laptop got too hot and I had to stop after 6 hours, or end of the semester, hurry up and panic incidents where there were sudden compatibility surprises. Nonetheless, we turned out to have a bit more of a steep climb than we had anticipated. One of the things that we have been contending with, I think as anybody who has been working with generative AI has been contending with, is just how quickly generative AI is capable of creating work for us. So years ago, when experimentation used to go very slowly, the overhead for data preparation was a very small percentage of our effort. And once experimentation became faster, every task beginning with, I could just format the data this way, I could just add this identifier, it would help the students go more quickly if. All of those I could just threaten to slow all progress to a halt. And so the problems were also not limited to preparation. Expert evaluation and the time lags and bottlenecks associated with it also became a much bigger problem. The kinds of hallucination errors we're all familiar with by this point turned out to be a large problem for us. Everybody in the room knows that 2 + 2 isn't 17. And do we all know how Myra Bradwell received her legal education? I've seen LLMs come up with 3 different law schools that they claim she attended. And finding out, where did those answers come from? How long does it take to confirm that there was never there was never a source for any of these answers. It turns out that, and I was not aware of this when I started this, that she read the law and took the bar. So all of these pieces come together and make for a lot of work generated very, very quickly. Now, as a slight digression, I do strongly recommend taking the time to review 2 research papers from the research team affiliated with the Stanford Regulation, Evaluation, and Governance Lab. The RAG diagram earlier was from their very recent paper entitled Hallucination-Free: Assessing the Reliability of Leading AI Legal Research Tools. Those collaborators have been making a useful distinction between correctness and groundedness when evaluating responses from LLMs. correctness refers to factual accuracy and in their framing, whereas groundedness refers to the relationship between the facts stated and the sources cited. And per above, regarding barriers to evaluation, ungrounded statements can be extremely time consuming to even try to begin to evaluate. And so here on the screen, we have one of my favorite quotes about generative AI. Most of us want to be focusing on interesting tasks. And given that, if I'm not alone, chatbots are particularly difficult not to anthropomorphize. The last thing that most of us wants is an overconfident AI assistant who runs around generating enormous volumes of tedious quality assurance tasks faster than any of us could ever hope to keep up with. And if our engineers, Eric and Vivek are in the room, Matt Carey and Sylvia Quache are possibly watching online right now, or possibly will catch this in the video recording. If they have to spend more time finding other people's mistakes than before, we're not really winning. And so what we have learned is that we can turn around and go back to basics. This screen grab is from a feature that we developed many years ago, which was really designed for a dual purpose. One was that we were very excited to have a natural language processing derived feature that could extract definitions from legal texts and attempt to detect where the defined terms were used in context, attempt to make sure that the scoping was correct, and attempt to then connect each term to its appropriate definition, making allowances for usage and so forth. The first time we deployed the feature for the public, we were very worried that it wasn't perfect. And so anticipating that possibly the public would expect the feature to be perfect, we prompted the audience by indicating that they were going to be given the opportunity to tell us, no, you've got it wrong. And so whether pressing our luck, we were deploying something that was maybe a little bit not ready for prime time or not. We felt that we were covering our bases this way. So we went to crowdsourcing as a way also to not just prompt the user that this might not be perfect, but also to collect information that they might be able to make use of and be able to help us feed back into our analysis in order to help us prioritize what was going to be most useful to try next. And so in the process of this, we did a little bit of an assessment and we refined all of the tasks in terms of crowdsourcing and tried to determine what level of knowledge and expertise was going to be required in order to do different kinds of tasks. At the highest level of expertise required, we had questions of scope and reading a regulation and figuring out whether it was within context or not within context. And at the bottom of the list was, did the definition get cut off, which pretty much anyone, even high school students could tell us in a split second. And so in 2024, we have had the odd experience that tech companies have spent billions of dollars over the past few years training the general public not to expect perfection from language technologies. But the evaluation features could give us an opportunity to make us communicate with our audience about what to expect and help us set the stage for continuous improvement. So what then do we do with it, with the language models? And one of the pieces that we've discovered as we've worked with these is that a lot of the time what we want is to take all of the symbolic AI work, all of the natural language processing that we're doing, all of the rule-based citation parsing and processing and everything else, and we want a language model to be able to do that for us. But what the language models are really good at doing is pulling together information and understanding, as it were, to anthropomorphize just a little bit, what is the average? What does this usually mean? What is the correspondence between lay language and expert language? And so to discover from even my pet hallucination engine, which is running Tiny Llama, that it can navigate from barking dog to nuisance is in some regards very exciting. So what we're taking away from this, we're learning when to be boring, when to invest our resources in streamlining all of our processes so that we can just go faster whenever we are trying out a new technique. And then investing our time and energy and focus on figuring out what the highest and best use of, or the fastest path to success of a new technology is going to be. Looking ahead, we are encouraged to see progress in the development and integration of language models and retrieval augmented generation in particular, and excited to see that on the few rides on the World Wide Web roller coaster that we may have left, we have a lot to add to the website that we're making for the public. Thank you. And now I hand it over to Craig.
Thanks, Sarah. And if I didn't say so before, we'll just hold the questions till the end, but we can absolutely applaud now. More than appropriate. All right, I'm going to talk about how the LII has been thinking about generative AI and some of our student work. I'm going to do this with the assistance of the Muppets, since I discovered in putting these slides together that Google Slides now has this massive library of images and GIFs, or GIFs if you must, that one can insert in their slides. In Google Slides. And so yeah, the Muppets are gonna help me out here. And like the Muppets, the LII has a very diverse and raucous kind of collections on our website, and that includes not just a lot of primary law, but an increasing amount of original content. Primarily these three bulleted collections here: WEX, which Nicole talked about yesterday, which is a 6,000 plus entry of mostly student generated definitions and articles on legal concepts, case summaries, that sort of things. Women in Justice, which is a hybrid collection of primary and secondary content in the form of mostly case summaries taken from around the world, having to do with gender justice issues, case summaries ranging from family law, property, inheritance type law, to, of course, all kinds of criminal law and other unpleasant things dealing with gender justice issues. And then lastly, our Supreme Court bulletin previews, which I'm going to speak about now as sort of a worked example, but I think where I get to at the end is pretty much equally applicable in ways to all of the original content work that we do with our student employees. So as I said, I'm going to talk about the Supreme Court bulletin previews. A first fair question is, like with Gonzo here, is what are they? And what they are is we have 36 law students that write these things for us, and we'll get into that a little bit more in a second. And here's an example of one. I used Trump v. Anderson, despite its potential triggering impact, for a reason that'll become very clear when we get to story time here in a minute. But each preview is formatted the same way. It starts with a plain language recitation of the issue that the court is hearing, a summary of what the case is about, a facts section, a section of the analysis of the legal arguments that the parties are making, which is distilled largely from the merits briefs of the parties, and then a discussion section of the ramifications of the outcome of the case, which is largely, though not exclusively, distilled from the amicus briefs in a case. And so next is how are they done? Much like the pigs in space here, the students work in teams of 3. In the middle, Commander Pig there is going to be a third-year law student who we call a managing editor. Again, we have 12 3Ls and 24 2Ls. So each team is 1 3L, 2 2Ls on the side there, and the 2L associates are reading all of the briefs, breaking up the work, collaboratively generating the sections of the preview I just showed you. It's going to the 3L to be edited for grammar and for style, for voice, all of those things we care about. It then goes up to the student editor-in-chief. She also edits it. It comes to me. I give it one more read. By then, there's usually very little left to do. And then we publish these things online for free. We also send them in a free email to 30,000 plus subscribers. Again, for free. But of course, free for the user does not mean costless to us. In the course of the year, the court now hears about 60 to 70 cases. We spend between $60,000 and $70,000 on this project every year. So for our purposes, roughly $1,000 a case. Little David Colarusso back of the envelope math there, I guess. But it's about $1,000 a case. And while we have adopted the language of the print journals, calling our people editors-in-chiefs and managing editors and associates, we have not adopted their business model, which is to say we pay our students for this work, which is why it costs us $60,000 to $70,000 a year to do it. The current Cornell rate for law student pay is $16.10 an hour. So that comes to roughly 62 hours per bulletin to get to 1,000 hours. And that seems about right. A lot of that work is reading, and then of course writing. There's also ideally meeting with professors to better understand the case, meeting with each other to collaborate, that sort of thing. And that's why it costs what it costs. Which brings me to story time and Trump v. Anderson. Now, this was the case about whether Colorado could keep Trump off the Republican primary ballot, right? And so the court agreed to hear this on a very expedited timeline. What that meant for us is our students had less time between when the briefs were in and when the argument occurs, since that's our publication deadline, since it's a preview. That was all going to happen on a very compressed timeline. And then I was also a little concerned because I assumed that there were going to be a large number of amicus briefs that were going to have to be read on this very compressed timeline. So after I finished freaking out like Beaker here a little bit, my first thought was, oh, I'm going to email the editor-in-chief and see if she has a plan. And of course, she was in class. So while I was waiting for an answer for her, I thought, well, maybe this is a chance to experiment with technology. This was early 2024 when this was happening, about 6 months ago. And in fact, I went back and found my email to the editor-in-chief. It was on January 6th, ironically enough, of this year, saying, hey, what's the plan? And, early 2024, but we'd all spent most of 2023 learning and discussing with each other at conferences like this, what Gen AI was good at, what it was not good at. Side note, one of the things it's not good at still or yet is I didn't want to count for this presentation how many amicus briefs were filed because I was being lazy. So I asked Copilot from Bing how many total briefs were filed. And it said, well, there were 3 briefs. There was a petitioner's brief, a respondent's brief, and an amicus brief. I said, well, I know enough about how these things work that I understand how it could make that mistake. I'll give it another chance. Okay, how many amicus briefs were filed in this case? It said there was 1 amicus brief filed in this case. And that was not the right answer. I'm not sure why Grover's so happy that they were wrong, but they were wrong. So anyway, one thing we do know that this technology is already quite good at is summarizing documents, right? So I started a free trial of askyourpdf.com. And I said, again, this is all in the minutes after I fired off this email to the editor-in-chief. And I uploaded the petitioner's brief to this particular piece of software that I chose for no particular reason, except it had a free trial. And I was in a hurry. And the software told me exactly what this brief was. And then it asked me, gave me a list of potential questions I could ask about it. The third one was very close to how I would anticipate using this tool for this task. So I clicked on that. And the software gave me 4 arguments that distilled out of the brief. These are the arguments that the petitioner is making for the court. 1, 2, 3 was the winner, by the way, and 4. And then just as importantly, if not more, so it told me where in the brief this was, gave me the page numbers. And I thought, wow, if we're in a hurry and we have a bunch of amicus briefs to read, wouldn't this be great? Because the students can just go to the arguments on the pin sites and read just the arguments. And just as importantly as telling us what are the unique arguments in each of these briefs, and by the way, there turned out to be about 75 of them, which are the unique arguments in this brief, but also which are the which arguments keep coming up over and over again? Because if they keep coming up over and over again in multiple briefs, odds are those are the ones that people feel have some merit on either side of the issue. So this is potentially a very useful tool to process this massive amount of paper that the students are going to have dumped on them on a very tight timeline. So as I was thinking these thoughts, my editor-in-chief got out of class and she wrote me back and she assured me that she had a team of volunteers that were absolutely and positively up to the challenge of getting all of this done, and I need not worry about it further. And I didn't, and they did. So it was all good. But this little thought experiment that one day got me thinking, well, how could we be using this technology in the generation of previews? And then how should we use it? And then lastly, what are we trying to do here? What's the goal here? And I actually put this last bullet on my slide to make sure that I remember to say the goal was not to cut costs. Now, one could certainly cut costs. Let's say it goes from taking 60 hours to put one of these together to 6 hours together. I'm paying these students by the hour. They've just taken a 90% pay cut. Not the goal. But the goal is lost student time, as everybody in this room knows, is very precious. If we can free up 50 of those 60 hours, what else can we do with those 50 or 60 hours? We could do this work for other courts, or we could just summarize important opinions of the courts of appeal. Something I've wanted to do for the 10 years I've worked at LII is we could read every cert petition, most of which get denied, right? They're 2,200 cert petitions. The court hears 60 cases, not a very good batting average. There's some good stuff in those cases that have just become the law of the land, or at least of the Ninth Circuit or the 11th Circuit or the Second Circuit where the case is coming from. And really nobody's capturing that as an information service. And we could use this same kind of technology to pre-read all of this stuff and say, these are the ones that are interesting. And then the students could do their thing. So there's some possibility here, but that very quickly led to, I don't have big data like David did. I have big animal. I'll take animal every time, but that led to big questions. So first of all, this one's fairly unique to LII, I suppose, in that our mission, simply put, is to use technology to make the law more findable and understandable for people. To what extent does that then mandate that we experiment with technologies and then come back to places like this and share our expertise and our experience so that everybody can be doing more and be doing better when it comes to playing with cutting edge technologies? But then even that potentially starts, in this particular case, which is what makes it so interesting to me, it starts to potentially rub up against the responsibilities that we've accumulated along the ways in 30 years of doing this. So for example, we have this very large readership. The site in general, not the bulletin previews, the site in general has almost 50 million unique users a year now. So when you look at only the American users and factor out elementary school aged people, that's about 1 in 8 Americans high school aged to death. That's a lot of people. And if we're playing around and experimenting and putting stuff online that's experimental, despite whatever caveats we may associate with that, we know from experience that folks are going to rely on it. And they're going to say, well, Cornell says. So that's a concern whenever we get into a new technology. But then specifically what I was excited to posit to this room, and I absolutely want to hear people's feedback either after the session or during lunch or in the hallway or in LinkedIn or wherever you can find me. Consistent with the conference theme of the unknown unknowns, I'm at a point now where I don't teach students, but I train them, right? And I take that responsibility very seriously. In addition to paying the students, we also say, come work for us instead of, or in addition to your print journal responsibilities, because you are going to get to flex intellectual muscles when you work with us that you don't necessarily otherwise get to flex in law school. For example, collaboration, writing for an audience that doesn't already know the answer like your professor does when you answer an exam, writing in plain language for an audience that does not have a law degree and a law background, all those sorts of things. And so looking through that lens, I think about In the simplest terms, if I tell my students they have to let the machine read all the briefs, am I doing them a disservice when they hit their firm 2 years from now because I've taken away from them a skill they're going to need? Or am I doing them a big service because they're learning how to use these tools that when they hit the firm in 2 years, they're going to be expected to use? To me, that is an unknown unknown. I've done a fair amount of asking around, watching webinars. I schlepped down to DC and went to a DC legal hackers panel of the people at 4 large law firms that are making these policies and decisions, and they don't know where their firms are going in terms of the nature of the adoption of these sorts of tools and the extent of adoption of these sorts of tools. In a much more grand scale than I do, they have business model problems in terms of if they're still charging clients by the hour and their clients still want to pay by the hour, they are disincentivized, to use a good law school word, from taking something that took 60 hours and making it take 6 hours. The same way I'm disincentivized to do it because I don't want to take money out of law student pockets. So I'm very curious to hear what other people are thinking in terms of where on that curve we might be, where on the roller coaster we might be, to tie it back to the theme as I and we at LII try to figure out exactly the extent and the way in which we want to incorporate these kinds of labor-saving, time-saving tools into the work we're asking our students to do. And that's it for me and my time, and I'm going to hand it over to Tim. Thank you. Was that?
Just press this button here.
Yeah, the forward on the clicker.
Okay, thank you.
Don't point at the screen like I did.
All right. All right, I'm just gonna run through a few things somewhat related, but maybe tie a little bit more into some of the projects I see free law folks doing, and some of the ways we see actual lawyers using AI, through our services and other services. So let me just sort of run through it. Let me see if this goes. All right. So first, in terms of the trend, there's really only one big trend in terms of AI that I see in the free law. And there's lots of things going on, but the real trend is the decrease in price of AI services. I mean, it's gone down a lot. So, OpenAI came out end of 2023, and they've got their pricing up there. You can see it. It's cheaper for academics, but and there's some free usage as well if you contact them. But back in just last fall, we were looking at GPT 32K. So the context of 32K. That was $60 per million tokens for input and $120 for a million tokens output. So, a million tokens, 750,000 characters or so, something like that. But, not, by the way, very affordable relative to using people to do different work, but not as cheap as today. So I go today, GPT 4.0 now has, 128K context window. It's, $5 per million tokens. Whoops. Well, if that had worked, if I moved it from Mac to PC, but that would actually say $2.50 for a batch. So for if you want to, at night or something, you don't need your answers right away. So quite a bit cheaper. So, well, and there we go. Overall. So overall, you're looking at a price drop of 96 to 98%, just, certainly within last 9 months or so. And the context windows increase. And that's just OpenAI. And so you go, okay, well, that's pretty good. But these prices are just going to keep getting cheaper and cheaper, especially for tech stuff. I mean, I don't think pricing, when you're thinking about different models or anything involving law right now, should really be a major factor for you. You should just sort of figure out what you want to do and plan towards the future, is where the puck's going, as Wayne Gretzky would say, not where we are right now. So look at your costs, but just realize your costs are going to go down quite a bit. One of the main reasons, of course, driving is everybody just wants to get market share, and Google's jumped in here, and Google has their own, right? So you can use Google's if you want. It's different. I'll put it that way, not the same exactly. But the Gemini 1.5 Pro came out, and that's a little bit cheaper for inputs, a little bit more expensive for outputs for the 128K token, similar to OpenAI's GPT-O. But they also have 1 million tokens, and in effect, you can get access to 2 million tokens for context windows. That's probably more than we're ever going to need for anything, to be quite honest. I think we're sort of there. It was mentioned earlier this morning by folks. I wouldn't worry about that too much. But, eventually even these prices are going to fall quite a bit. So, sort of the main thing that is going to be the focus, I think, of most of these AI companies are things like images. This is my dog. It's a pug on a motorcycle with an American flag right there with Justia in the hat, right? I have a pug. I don't know if you guys see my pugs. And things like video. This is, so it's, we're all worried about law and text and everything else. That's relatively straightforward for these guys. Their big movement right now and their big emphasis is on images and videos. And then, next time you hear the audio of Trump or the video, he'll say, I never said Hillary, lock her up. That was AI type of thing. And you might go, he might be right. Maybe it was, because AI is going to get really, really good. So, but that's where their big focus is right now. The text, we're just going to get wrapped up with it. It's going to get better and better. But I just think the prices are going way down. So if you're doing free law stuff, it's going to be, very, very inexpensive. One other one I want to quickly mention, that's AWS. They've got a lot of different models online. So outside of OpenAI and Google, Google, you can get stuff. Microsoft, you can get different models as well, not just OpenAI. But there's a lot of other models if you don't want to run it off your own machines. So you can actually get access to these things. You can sort of run them, and not different pricing, but they're all competing right now. And we'll sort of see where things go. And as far as what's driving the whole business, I know there's all these companies and everyone doing everything, but there's only one right now, one monopolist, and that's NVIDIA. All right. That's not going to last forever. But that is, if any, to the extent we have any pricing being held up right now before it decreases, it's NVIDIA not yet having competition. That will happen, and then prices will fall even further. But that's your one monopolist. The other folks are the cloud computing companies, but they're not really monopolists. So, Google and Microsoft and AWS. And even like OpenAI, I know OpenAI people think it's a company, but they get money and they just give it back to Microsoft. I mean, that's all it is. Microsoft gives them money, they give money back, and it's just cloud services. So those, the models themselves, you could get access to the models. Anyone can go read the models if they really, the actual math models, not just prompts and stuff like that. But that's all available. This is about cloud services at scale, which is very hard to compete with, but it has some competition in it. And then NVIDIA, which has no competition right now, because gaming chips and, soldier going left or right is similar to what's my next word in my sentence, right? It turns out to be basically the same thing. And of course, they also do crypto. So they got that too. And this gets back to sort of what I was saying last year, is that all this AI stuff is going to become like spell check. It's going to be everywhere, right? It's just going to be part of your software. It's going to be part of everything you do. Google has it. You can put it in Microsoft Office. It's special right now in certain ways for text, but it's not going to be special later. It's just going to be what it is. So you might as well just teach it to the students. They're going to use it anyways. The professors should learn it anyways. It's not really a choice. So you could debate it today, or if you want, or whatever. Dave was sort of going through, I don't want that in my classroom. It doesn't matter. It's going to be there anyways. It's just whether you want to do it now or later. It's not, we're past that part. And the other thing I wanted to sort of mention, I know there was talk about engineers on the big speech yesterday, engineers versus humanities folks. I don't really think that's the breakthrough. I think, this is being driven by money, and I just think there's so much money in it right now, and there's so much. There's a lot of reasons. There's a lot more money sitting in the market than you think, and they're just sticking all in AI, and it's this rush, and that might be a bubble. Who knows? But that's what's driving it. This is just a money play. That's capitalist system. You might say run amok, but if policymakers want to make changes, they should do it. If they don't, you'll get whatever the venture capitalists and private equity guys and some investors want. And so, not necessarily. Well, I'll leave it there. So. I brought up this last year, and I bring it up every time I talk, but it doesn't matter, because I'm going to bring up the accuracy stuff anyways, because this is the key thing to me, especially with law, right? Hey, look, the AI passed the bar exam. Well, so it got 60% of the multiple choice questions right. Try doing that in a court case, right? Oh, I was kind of good and I got disbarred, right? I mean, it's not, whatever. So again, you don't want to be this dude, right? This is what I think lawyers are looking at, because we have lawyers that use our system. Like, we have a bunch of stuff, right? We have things that help you write content. We have things that help you do some research stuff for attorneys only right now. And I'll just give you an example. We have one thing that helps you write a page of content. You know, I'm a Miami medical malpractice lawyer. Write me a page about medical malpractice. And we've got a disclaimer at the top. We have disclaimers on every paragraph that's written, right? Just a lot of stuff written there. And we don't even put it into their blog or their website. We make them download it as a Word document so they can edit it and then put it up. And I swear to God, these guys clip and copy it with all the disclaimers and paste it right into their website, to the point that we now have to have a check when anything gets entered into the websites to see if these disclaimers exist. And when we were mentioned to these first guys, hey, you can't do this. And by the way, this is yellow highlighting with red text in bold above every paragraph. We mentioned the first time that they took off the top one, which is the longer one. They kept all the ones on each paragraph. I don't, but that's attorneys. So we have a lot of assumptions that attorneys are going to spend lots of times, whether it's writing briefs, you know, like this guy, or Michael Cohen and doing some research software and whatever, or doing their websites. That's not true. They look at, because it comes from a computer, they go, it must be right. It's different. Even Google links, you link to a website, you go, it's from a website. I can see a little personality there. When it's coming from a generic text box and it looks like factual stuff, and especially ChatGPT makes it sound very convincing on stuff. People just go, yeah, that's it. Yeah, I'm not really, I checked it, but they don't check. All right. We've had the same thing. We've had bloggers write blog posts where we explain to them, you cannot trust this stuff. And I swear to God, they put up the blog post with the fake citations. It's not as bad as doing it in court, but it is bad enough to be contacted by the disciplinary committee of their state bar, saying, what the hell are you doing? Where are these cases from? And then watching them eat crow. They did get disciplined, but those blog posts came down. And this is after they were explicitly told individually not to do this. And I know that because I'm the one who told them not to do it when I was showing how ChatGPT worked. And damn it, they still did it. So anyways, I want to make sure that we understand this is not pure accuracy, no matter what you do. Whoops, I think I'm my other thing here. All right. Then we got, of course, the legal ones. We got Thompson, Lexis, and VLex, is out there. I think VLex is doing a good job on stuff. And you had the Stanford report. Now, whether it's practical or the West one, I'm not overly worried about that things weren't perfectly accurate. And, and you can look through it. Thompson, I think actually is probably better than sort of comes out even on the redo, just because they give so much more information and things. But regardless of all that, you can't expect this stuff to be perfect no matter what. I mean, I think Lexis advertise it in certain ways being no hallucinations or errors, whatever it is. They can't do it. And I don't think you're gonna be able to do that no matter what. And the reason is I don't think the law is right all the time, right? You can't trust the documents that you're basing anything off without a little bit of legal knowledge to sort of figure out what's what. So, let's just sort of run through a couple more things here. So this is from last year. I tried to repeat this with the new stuff, but it's always a good one from last year, which is the Mississippi one, right? Where you would ask ChatGPT, is same-sex marriage legal? And would say, sometimes it would say it's not legal. Sometimes it would say it is legal. I just tried it 10 more times. It showed up legal every time this time. But you can still do more esoteric ones with ChatGPT or even the legal ones where it'll slightly mess up. So if you're doing like Maryland law, you want to make sure that you don't accidentally get some Delaware in there, right? As far as like dram shop liability or something. And that's certainly I have no doubt that the legal providers can take it and really segment out the stuff, like the University of Washington's doing with the Washington law to make sure you're getting Washington stuff. None of that Oregon stuff, which, you don't want that crap showing up in your answer. And you could do that. And I'm sure that Thompson and Lexis can do that. I don't know if they're totally doing it right now. I don't know exactly how they're breaking it through, because right now it's very, very hard, not just for law people, but for everyone to do anything, because the models on the back end keep changing like every month. So you start working on something and things change. And you don't have the stability to sort of fine tune your stuff. I want to put my federalism layer on top of my AI stuff. Well, you can, but now you're getting different answers, and you got to keep coming back to it. So, and I know that from our own stuff that we do for summaries and stuff, it keeps changing. Even when it's the same model, it'll change on a week-to-week basis. So again, this is not really the fault of ChatGPT. In this case, this is what the Mississippi Code says. And we have a lot of people still write to us on Justia telling us that, same-sex marriage is not legal. You guys have an error in your, sort of summary of a case because here's the Mississippi Code and it's not legal in Mississippi. So, and they just go to the code, and Mississippi is not going to correct this because codes are not laws. Codes are legislative intent documents. And that's how you need to look at it, especially in some states. Although I would say red states right now, but later on it might be blue states when the Supreme Court changes around, and you'll keep some things on, but abortion will be illegal, but you'll still have abortion rights in, Michigan. But, we know the Supreme Court ruled the other way at some point. See how this election goes. We'll see where it goes. And then the other part is just trusting the documents themselves. Again, I showed this last year. This is a docket filing in a federal court case. And I see a lot of people say, oh yeah, we're doing autocomplete on all the filings. Well, I don't autocomplete on this guy. I mean, I think the Philadelphia Eagles stole a social security number or something like that. And it was a big thing. We had the blackout social security number. So otherwise it was showing up online. And then of course, same things can happen with like images. So my pug image, and then you might get an upside down flag and you might say, well, this is an error, but maybe I did this on Truth Social data, in which case it's perfectly fine, right? Or maybe my wife did it, in which case, it's just the way she did it. Who am I to correct her, right? She's got, her own thoughts. She went to a good law school, better law school than I did. Or maybe it was just a mess up by OpenAI. You don't know, right? So the same thing's true. Normally I would show you the 6-finger person, but this is more, it's a law. It's a law webinar. So, again, this stuff could show up messed up all the time, and you just have to be aware of it. And then, the other part I would say is you got issues with what is the law today, what is the law tomorrow. So if we look at Chevron or, Chevron deference, you can look at it for like a few more days, and then you can ignore this summary. You guys will have to update it. That's going to create chaos in the courts. And it's going to create chaos with everything that you do for research. I mean, this is not all right. I'm not saying Dodd's a big deal, right? That's a single issue. You can sort of, okay, you can learn that. This is going to hit all these other ones too. I mean, I can't, we'll see how it goes, right? But, we'll see how it goes. I hope the people who voted for Jill Stein enjoying their time and protest. Might have to protest again. But this is incredible. This is going to be bad. And but from an AI standpoint, you're not going to be able to trust your data because your data is going to be outdated immediately. And it's very hard to put layers on top, getting the sort of the timeliness and knowing what's the latest ruling and setting that aside immediately is hard to do. There's always sort of a delay. And then you really have to get that time preference, which again was brought up this morning. All right. Those are the big things to me. Prices are coming way down, especially for text. It's going to be easy to do. If you want to do it, go ahead and do it. You should get some credits as a university, no matter what. Google will give you credits. Or even ChatGPT will get some stuff if you want to do it. You could also propose projects. These guys, they're very interested in anything. They're interested in law too, provided there are certain checks on it by folks. On the free law side, I'm just going to run through some of the things that we're doing and some other folks are doing, and sort of run through it. So. All right, let me just start. I'm just going to list these ones, and then I have one secret one at the end, but you'll have to wait for that one. It's a good one. All right, case law stuff. You've seen this. It's basically summarizing cases. We use it now for our drafts. We use it. Other people have done it. They've gone through and they've been summarizing cases. It's really good for that. It's actually good at getting to the core issue of the case because it actually goes down to the holding. You can sort of find out what was really the deciding point. Not every single issue. All right, well, diversity of jurisdiction. Okay, that was this way, and there was a minimum amount in dispute. Okay, got that one right, and then but you get to the main issue, and it's very good for summarization on it. I do think. The Iraq stuff we got to play with a little bit. We're right now just doing court summaries as most people are, but I think it could get there. The main thing with this stuff, and I've seen lots of people do it. A lot of free law people have been using the summarized cases. Don't summarize the opinion and the dissent at the same time. All right. That's the thing you don't want to do. Just do the opinion and do the dissent as a separate summarization if you want to do it. All right. If you don't, otherwise, about 15% of the time you get it wrong. Which not huge, but not good. Right. It's not. If you don't do any of that, it's still wrong sometimes, maybe, percent or two at a time, but it's mainly wrong because it focuses on the wrong thing, not because it gets the actual answer wrong. So, but that's the main thing there. And this is getting more and more cost effective. Again, it's fallen like 96, 90, 98% so far. You can batch this stuff if you're doing archive stuff. So really good. Codes and regs. So, a couple of folks. The other thing I should say about case law, it's also good for classifying it for practice areas and things like that, which we use to classify it for which mailing list it goes out to the next day when we do our summaries. We also do drafts though. We still have checks, a lot of different checks that go into it. We don't just AI it and immediately send. We have a lot of different sort of checks and things on it to make sure things are okay. For codes, it's also good. It's pretty good, certainly good for tagging codes, classifying, summarization. The stuff with codes that us and some other folks are working on is so there's different items. You can get different session laws coming in. How could that be attached to the code and sort of trying to get it updated in real time? And then also just taking cases and getting cases that relate to that particular state so you can make sort of annotations. And that's an ongoing basis. So you get new case comes in, it mentions a code section, you try to focus in on it. There's a little bit, sometimes it applies to a code section that's not mentioned. And so there's some issues there, which hasn't been really solved in some ways. But hopefully at some point, just getting how the code section is related and figuring out things are, sort of related to each other. When one thing applies to this, it really applies to a bunch of items. Like, Chevron might apply to one thing, but it's applied to everything, right? To a certain extent. How you sort of deal with that. But this is the annotation part thing, I think is really good. The summarization's is pretty standard. Summarization classification of text itself is pretty fine. No problem. Court briefs. So here's another one that a lot of folks do. Here's like court listener stuff. So briefs, it's the AI stuff. I don't think it's great at writing briefs. It's great at giving you suggestions for it. I mean, you can do the basic structure of a brief if you want it written, but if you've got certain detailed issues, you really need to get in there and sort of play with it a bit. So it's not quite, let me pull this up here. Not quite exactly sort of, perfect in sort of writing it, but certainly as a suggestion mechanism, it's quite good. And getting the basics is good. But I would normally encourage people, if they have a brief, to at least run it to get new ideas, because that part is great. It's, the AI stuff really can go through it. The one thing, similar to beforehand, you got to make sure you know what briefs you're looking at. So ideally, you would take your briefs, and if you're doing an unfair competition claim, you don't really need a bunch of briefs about divorce cases. All right. Try to sort of segment it out and tag it so that you're sort of getting the correct ones related to the correct summarization. And the one thing about briefs here is that, there was that case, White versus Thompson and Reed Elsevier folks, where basically Thompson and Reed Elsevier were fighting for fair use, saying that they could put all the briefs up in their system and the lawyer was not able to have a copyright. And they walked through the fair use test and, it was basically, it's not really competitive with the work being done for a client. However, that's using it as a research tool to look it up. That might be different, might be seen different if they're actually using it to write briefs, right? If you're actually using it as part of your autocomplete stuff, maybe not. Maybe it's similar to other, partially used stuff that's being partially used. But I could certainly think of a way that I could take a set of briefs and I could take them from SCAD and ARPS, right? I could take SCAD and ARPS briefs on unfair competition. And I could say, write my brief in the SCAD and ARPS style, right? Just using theirs, right? Or doing something, from Wilson Sonsini on, some sort of IP licensing dispute, right? Give me their style of it and just take theirs. Cause I know they're pretty good lawyers and they're pretty good litigators. So you can sort of see, it's like Taylor Swift for briefs, right? It'll be very exciting for everybody. At that point, they might have some more say in terms of what's being done. But this all could be done right now just by sort of tagging and collecting the content. I mean, so much of this is just figuring out what's what and sort of getting it segmented out correctly and then running it. That's really what Thompson and Lexis are doing. They just have everything tagged. You as free law people or us as free law people, we have some stuff, we don't have everything, and we don't have as much resources because we're doing it for free. But again, the core stuff's getting cheaper. And in business contracts, I'll run through this. This is just like briefs. So a place to go, you go to Edgar, you can get all the contracts here. You pull out the Edgar filings. They have all these great contracts written by top law firms for public companies. Law Insider has done a great job of stuff. We have a full set, of contracts, mostly full set. And you can strip out the clauses, do different things like that. The interesting thing about contracts is, and briefs as well, is that neither of those two do you need completeness to actually be able to use the AI. Case law and codes, you want to make sure you have the latest and the complete set. Not true with briefs. You just need a good set, right? You can get everything a little bit better, but it gets marginally less valuable. Same thing with contracts. You can get a set of contracts and you can use that to create a contract, and that works out pretty well. Similar to briefs, if you have, again, you can use it to write a brief, you can use it to write a contract, but you better double, triple check it, not just take it. Because what will happen with your contract writer, sometimes there'll be great contracts, except they'll leave out a clause that turns out to be really important, right? Sometimes, lawyers leave out those clauses on purpose. Sometimes the AIO will do it, probably by mistake. And the other part I would say, again, with contracts as well as briefs, is you really want to segment this stuff out. So you really want to get it, if you're doing an aviation licensing deal, you don't need some HR contract for an oil company, right? Try to pick and choose the set of contracts you want to autocomplete your stuff off. This is just, definitions are different. Same, as the Cornell folks also have done when they've gone through definitional checks, trying to show definitions used differently. The same's true in all these other documents. Try to find out what's what and choose that data set to do your autocompletes off. And then you just sort of go through it. And again, I'm very uncomfortable saying this is a complete contract, but I'm very comfortable saying, here's a contract, give me suggestions based on this data set over here and what they have there. That works great. And you'll find stuff. It'll give you suggestions even because it has to. For some reason, they always have to, the AI always has to give suggestions. It can never be satisfied, but that you can check them out and you can like them or not like them. All right. And this is the last AI thing on the free law side. So I don't know if you guys saw this, Jerry Goldman, Northwestern guy, he worked at Chicago Kent too, as well. But he had put up the Brown v. Board of Education, and he took AI and he recreated the voices and did the oral arguments. So if you go to brown.oia.org, you'll see this. He just got released right on the anniversary of the case. So this is an example where you could take AI on the voice side, similar to video and the photo side a bit, but actually apply it to something that's on the law. Now, realize this is, it is AI created voices, but you had all this other voice data that you could use, that you could really use it to create it. Now, he went ahead, he actually had voice actors do it, and they fine-tuned the voice actors reading. I think if you ever wanted to do stuff like this, you could also probably just use AI directly. I think AI is getting pretty good. If not, at some point, you could probably do it that way. But this has been quite a successful endeavor that he did. It took a lot of effort, but it's quite good. So you should check that out. There's another use of AI that's for free for people for educational purposes. There's nothing to do with briefs or contracts or case law, but has a huge historical importance and very interesting. You can listen to the whole thing. It's really good. So with that, I will turn it back over I'll do the thing with the questions. All right. Thank you.
If there are questions, Dan has mic. Otherwise, we'll go eat lunch.
Name of the dog.
That's Rio, a real dog. So, but we have Zoe now. So, go ahead.
You have your Zoe shirt on?
So, like the correct one. I don't have my Zoe shirt. I thought I did. I thought to take off my clothes. So, I apologize.
I'm sure there are people in the room would be happy if you took off the word.
My nephew's going there next fall. He did good. So, he's in the sports. Right. He's not ready. He's not exercising. He likes to jog.
Okay, I think that means we're just about done. Thanks, guys.
Thanks, everyone.